This conference will now be recorded.
All right, good morning. We're ready to get started. If you would like to get started with the Sexual Misconduct Committee here in the room, I'd just like to let you know that I am here, Kathy Pollock, and then Kim Anderson, Chief Legal Counsel, is also here.
Okay, everybody hear me okay?
Yes.
So this is the May 13th, 2020 State Medical Board of Ohio meeting, and we're going to get started with the Sexual Misconduct Committee. So we have a few items on the agenda today. And Stephanie, if you'd be so kind, maybe do you want to take us through the FSMB consultation review to start?
Sure. So we've been working with the FSMB audit team. Stuart and I have. There are two members that are leading up the project team from FSMB, and then they have a group of folks on their audit team from around the country, people from other state medical boards as well as people from FSMB. What we've done to date is provide them with a lot of documentation. So they've been doing a paper review. They've looked at things like position descriptions, tables of organization, our workflows, our protocols, old manuals, new manuals, training manuals. So they are really looking, they're doing a really intense desk review right now. Over the last week, they provided us a list of names of folks who they're going to be interviewing as part of their audit review. So they'll be talking to some of our staff members who are part of the complaint processing. And they'll also be talking to Dr. Rothmel and Dr. Safran as secretary and supervising member. And they'll be talking to Dr. Schottenstein as well. So they have our half-hour to hour-long interview scheduled over the next, I think, 3 days. So it's the 14th, 15th, and 19th, where they'll be working with us, doing those interviews, and then compiling a report for us. It's been a very interactive process. They've been hands-on, easy to work with. Just based on some of the questions that they've asked us so far in the document review, I feel like they have a good sense of what they're looking for and kind of what the mission is. They are expecting to wrap everything up by the end of this fiscal year. So I thought that was encouraging. And I can't remember if we shared at the last board meeting, we had accepted that bid from them previously. I think it was for $30,000. And they have, because they are not coming to us, they cut all of their travel out of the procurement, so that saved us some money, and then they gave us a discount as well. So I think we are down to $15,000 for that audit review. So I think the FSMB staff is giving their time. They're only doing a per diem for the folks who are not FSMB staff members, which I thought was very generous, because I'm sure they will be having budget challenges as well. But again, it's been an engaging process, and I'm excited to see how these interviews go and kind of what that feedback looks like from them. We'll certainly have a chance to review that report before it's deemed final. We'll bring that to this committee for review and sign off before we as a board sign off on it fully. Any questions?
Sounds great. So after the audit is completed, then we circle back with Office of Budget and Management.
Correct.
For their audit. Okay.
That's right. That's right. So after we receive FSMB, we take a look, we see what sort of implementation we think we want to do, what what the lay of the land looks like from us from FSMB, and then we go to OBM internal audit to say, okay, now what? And what that process looks like. My guess is that they would take a sliver of that work and say, okay, now we'll do a desk review after you implement some of these changes.
Thanks, Stephanie. Anybody else have any questions about that? Yes, sir. Mr. Donadakis, hi.
Thank you. Just curious, is Office of Budget and Management charging us for this desk review or any additional work that they're going to do?
So we don't know yet. I typically, if internal audit comes in and does something, they do. I don't know, given the unknown of all of the budgeting world, what that will look like. And frankly, I think, it becomes an affordability question for us as well, as we're looking at everything else. So yeah, you're sort of reading my mind on that one. I don't know what we'll be able to afford and what they'll be able to do for what we can afford.
Thank you.
Great. Any other questions? Okay, thank you kindly. So maybe we can move on then, Stephanie, to the victim advocate training update.
Sure. Just a quick update on this. I just wanted to highlight, we had James Roach, who is our Chief of Investigations, worked with the Ohio Victim Witness Association and scheduled a training that was really tailored toward medical board attendees. You know, I think he's done a great job of working his local resources to provide trainings for his investigators in this downtime. You know, obviously they're not able to go out and visit doctors' offices because a lot were closed for that long period of time. So he arranged with this Victim Witness Association, who frequently work with prosecutorial offices, to do a training on the kind of where the victim fits into the complaint process and the quasi-judicial process, if you will, and it was very tailored toward the medical board. So it was a half-day training, and he was able to, it was a webinar, and the whole investigative unit, as well as the enforcement attorneys, as well as our legal team, participated in that victim advocacy or the victim advocate training. And so, you know, I just thought it was, I thought it was a good use of time in their downtime, and I think that it just sort of speaks to that this is a continuing education thing with our staff, and just kind of ingraining it in the culture. And how do we use a victim advocate? What is the victim experiencing? Some of this is kind of learning some of the science behind how the victim processes on their end, as well as how the respondent may be processing on their end. So I was just really pleased that they took the time to do that, and that he worked so closely with them to actually tailor it to the medical board's needs and the medical board process. It's not often that we can get training that's really tailored to kind of what we need. Sometimes we have to sort of fit it into what the rest of the world is doing and then tailor it ourselves.
Great. Could you speak for a moment, Stephanie, to the sort of change in thinking that we've had about the way in which we're going to use victim advocates? You know, our initial thought was that we were going to contract with victim advocates, have them regionally based. And now what we're thinking at this point is utilizing staff that we already have that has background in victim advocacy, and keeping it more internal and centralized. Could you speak to that?
Sure. So we did, for a while, we were running sort of a concurrent pilot where we were having the contractors as well as the internal resources serving in the victim advocate role. What we learned was that our staff is much more comfortable with the continuity of utilizing an internal resource. So we have internal staff who have this training. You know, I don't think it's necessarily the perfect solution right now, because we're going to have to be very careful about what our staffing model looks like for the future. We don't know what budget looks like for next year, but ideally, if we do use this internal resource, it would be a dedicated resource. And maybe even a resource that other boards or commissions could use as well in their investigative processes, and maybe even partially fund with us. You know, I think we can start to get creative on this a little bit. But I think what we definitely know is that the contractor is not an ideal situation. The contractor does not provide continuity. The contractor, the availability isn't always there. It's hard to work in real time when working with the contractor. And to that end, if a contractor gets, you know, kind of pulled toward another project in his or her own life, then we sort of lose that. So having a dedicated resource, I think, is really the ideal way to go. How we fit that and mold that into next year's budget is one of the top staffing concerns that I think we need to work through. Right now, we have a couple of investigators who have that background, but they also have full-time investigator jobs. So again, we're going to have to, when we sit down and through this, I think with finance committee, we're going to have to really work through what do the resource allocations look like for next year. it's not something we can stop doing, so we have to figure it out.
Thanks, Stephanie. Any other questions about that? Okay, Stephanie, do you want to give a bit of a background on a historical case review right now?
Sure. So with our historical case review, we have seen a lot of progress. I think the last time we met, because we did not meet last month, we were sort of sounding the alarm bells that it was not going as quickly as we had wanted. I'm going to let Stuart dive into the details on where we are numbers wise, but I will say that we are progressing quite well in looking at the cases, getting those cases reviewed by experts, by outside experts. And we've also had a little assistance from the Attorney General's office in their downtime. You know, they've all had so many hearings canceled that we're able to, you know, to utilize some of our AG resources. You know, if they have a conflict, they would not participate in that particular review, but we've had a couple of free hands on board, which has been extremely nice to be able to utilize that resource. Stuart, why don't you give us an overview of the numbers, and then I'll give a little bit of background on what's happening with the cases after they've been reviewed by the expert witness.
Sure. So as of yesterday afternoon, we had been invoiced for just under $85,000 by our external contract reviewers. They have completed 630 reviews, so that's actually 50% now of the entire cases to be reviewed. We've crossed that 50% threshold. Speaking to the AAG contribution, to date that they have reviewed 40 cases on their own. That has resulted in 80 hours that has been logged by them that we have not had to pay contractors for, so that has saved us about $4,000. In terms of the average number of reviews done per week, over the last 4 weeks, we've seen 55 a week on average. And over the last 8 weeks, we've seen 52 per week. So we are experiencing a much better level of consistency in terms of output. And that's gotten us on a much better path for getting this completed in a timely sense. So if you look at all other things being equal, nothing else changing, you know, we're slated to get this done by maybe the end of August or sometime in September, if nothing else changes, contractors, AAGs, that kind of thing. So.
Yes, Betty.
I think you're on mute, Betty. There you are. Yep, we gotcha.
Okay. Stuart, remind us of the total caseload that we're dealing with?
Yeah, we started out with 1,256 cases to review.
And that's out of a total of, when we first got our bucket, when we went back the X number of years, we went back, they were 25,000 or 26,000, or do you remember what the bucket was that we brought it down to 1,000?
I don't recall offhand what we started with the whole 40-year case review versus the 25. I'm sorry.
Okay, thank you.
I think that
it was a little over 2,000.
That's what I was going to say. That's my recollection too.
What is it?
Yes, it started with 2,000 if we were going to go back 40 years. And
okay.
It went down to the 1,256 going back 25.
Mm-hmm.
Thank you.
So, Mr. Ganadakis, hi.
Thank you, Doctor. Stuart or Stephanie, just, you know, looking at your crystal ball, do you think that we would, you know, it would be a safe assumption that will be done by year's end, or is it impossible to predict at this time?
I think it's a safe assumption that will be done by year's end.
Thank you.
Yes, Mr. Jacqueline, hi.
I don't know. Have you guys been keeping a running total? I mean, this is the first wave, right? And then if this passes the gauntlet, it would be pushed forward to action or a next review.
Correct.
What's running on that? Do you have any feel for, I mean, is it 90% are moving to the next run based upon what you're looking at, or any feel?
Yeah,
Right
that's a
now,
great
it's
question.
about half. Oh, sorry, go ahead, Stephanie.
Yeah, so we are now to that stage because we have that first big push done and reviewed and all of the expert reports compiled, and we've spent a great deal of time working out our internal process. And so what happens now is we have a team, an internal team that takes these. Once the reviewer recommends that something else needs to happen, and sometimes they're very specific in their recommendation, other times they say, you just need to go back and redo this, right? Some of these were aged case reviews that they just closed because they aged out. That used to be a protocol. So the folks who on that internal team, we have 2 investigators, an investigator supervisor, as well as an enforcement attorney. And they sort of work the case as a team. They take a look at those cases. The investigators, for the ones that have recommendations, they do what we're calling a preliminary investigation, just a little bit of a desk review. They'll run an ORS report, run an OLEG report, sort of look at the recent activity with that licensee, and then figure out what next steps look like. Sometimes that means following up on the reviewer's recommendation and going back and doing a more thorough investigation. You know, obviously this involves us then working with the complainant or the victim, and that's where we're going to have to work that victim advocate in. Sometimes it's a matter of not doing more investigating, but just going right to enforcement. Sometimes the investigation was done thoroughly, and now it's a matter of enforcement. And these can be in those 3 different buckets. They can be relative to the complaint itself. It can be that maybe there was a failure of a duty to report by another licensee, or it could be one of those law enforcement notifications. You know, I think if I have my crystal ball on this one, the law enforcement notifications will be probably pretty rare given the time of some of these cases. We would be notifying law enforcement for criminal activity, and most of these, the statute of limitations has run. There might be a check on recent activity. You know, it's really kind of, again, based on what that team assesses. You know, I think they have a good rhythm of figuring out what to do with the case. And then they're bringing those cases that we're recommending for enforcement, they're bringing those in a batch to secretary and supervising member for approval for next steps. So in rounds, in our normal round review, the enforcement attorney who's on this team will bring those forward and explain what the team has decided to do with those cases. So I think we have a pretty smooth internal process. When we look at how do we think this will shake out, it's a little hard to tell because the way we prioritized the review was we took the licensees who had the most complaints against them. And with that, I think we have the more complicated cases at the beginning. And so I explained this to the secretary and supervising member the other day. It's feeling like a lot at the beginning. I can tell you just from what I see on the back end of checking in some of these cases as they come back in from the reviewers, these get a lot, I hate to say the word easier, but easier as we go through them. They're single complaints. They are they're much less complicated fact patterns. They're very, and sometimes we've even taken action on some of those cases so that it's pretty, or complaints, it's pretty cut and dry. So I think, again, that's too why we're seeing that that review time increase drastically. You know, for the first couple months of the review process, it was taking a reviewer on average between 4 to 6 hours to review a complaint. I think we're down now to, I think the recent batch, it's taking them, from what I'm seeing, it's taking them about an hour to review. So it's sort of it's a quick, heavy on the front, and then we're sliding into a little bit of a quicker process on the back end.
So you said, I'm sure I quite got the answer to the question I was asking though, which was based upon our run rate right now, what percentage do we think are moving forward? Realizing that as you explained it, it may be top heavy right now, it may be 50, 70% now, it's going to taper off to set 30. I understand that. But like, kind of what are we looking at right now?
Yeah. I think we'll have a better number. I think we could have a real number on that next month. I don't even have a guess on that number this month, because we're just sending our first batches up through for approval to secretary and supervising member. So we're just getting that internal process going on what happens next with the case. I think once we batch do a couple of batches of those, I think we'll have a better sampling for that number.
Okay, fair enough. Thanks.
Hi, Ms. Montgomery, go ahead.
Hey, Betty, can you take off
I think you're
mute?
on mute. Sorry.
There you go.
For some reason, Tessie has control of me, so which is probably smart. For the AGs who did some of the work, were they our AGs, or was the victims advocate folks over at the AG's office jumping in? Who did we have doing this? Our regular staffing AGs?
Yeah, they are folks from the Health and Human Services section.
And they just, that was great. Are they continuing to help us?
Yeah.
Save money.
They're saving us money. They went through the same training that every other expert reviewer went through. They've gone through the same quality assurance checks. I think it's probably safe to say they understand the process a little more than some of our outside experts. So it was probably a little easier to get them to understand how to do it because they speak the words. So yeah, it's been extremely helpful having them. Every little bit helps.
And are they still doing it?
Yes. Yeah.
Great.
Anything else, anybody today? Okay, so I think that concludes our agenda for today. Motion to adjourn?
Motion to adjourn.
Oh, Dr. Bechtel, is there a second?
I'll second it. Hey, Michael.
Ready? Yes.
I don't know that you know that Dr. Beckel is a national figure, as he was commented on last night on national television.
Wow.
I don't know if Mark was that, but if your friend John Kasich mentioned you last night.
I didn't know that. So maybe that's a
so you're famous. I second the move to adjourn. I just want to let Mark.
Thank you.
Sorry if I can interrupt. If I can interrupt for just a moment, Dr. Bechtel was not officially a member of the committee. But Ms. Montgomery is, as is Mr. Gonadakis and Mr. Jackaloni and yourself, Dr. Schottenstein. So if someone else can make the motion to adjourn.
I make the motion. Second.
Very good.
Okay. Very good. Thank you so much.
Thank you.
So all in favor of adjourning?
Aye.
Okay. Thanks, everybody. See you soon.
Thank you.
This conference will now be recorded.
Present.
Dr. Sohn.
Present.
Dr. Edgen.
Present.
Dr. Johnson.
Present.
Dr. Cacarella.
Present.
Mr. Gonadakis.
Present.
Ms. Montgomery.
Here.
Ms. Montgomery? Okay. Dr. Feibel?
Present.
Here.
Dr. Bechtel?
Present.
And myself, Michael Schottenstein. For the first order of business, I'd like to say a few words about Dr. Richard Edgen, currently serving as Vice President of the Board. Dr. Edgen's term on the board expired on March 18th, 2020, but his term can continue for 60 days beyond that in the absence of an appointment or reappointment from the governor. Dr. Edgen graciously agreed to serve those extra 60 days. Since Dr. Edgen's appointment to the board in 2015, he has served with distinction as a member of the board, as well as stints on the licensure committee, the PA scope of practice committee, the committee on prescriptive governance, the physician assistant policy committee, and a number of ad hoc committees. On behalf of all the board members and staff, I would like to thank you, Dr. Edgen, for your years of service and engagement with the board. We have a plaque for you if someone's able to hold that up, if we have that. So I don't see it, but we have a plaque for you, Dr. Edgen, in recognition of your contributions to the board's mission. We look forward to being able to meet in person again so that we can give Dr. Edgen a more formal thank you. It's certainly been an honor and a privilege serving alongside you. I've learned so much from you. I wish you all the best, and I thank you so very much.
Thank you very much. It's been my privilege to work with all of you.
Thanks, Dr. Edgen. Moving on for a moment then to the minutes review. Do I hear a motion to approve the minutes of the April 8th, 2020 board meeting as drafted?
So moved.
So moved.
Oh gosh, Dr. Bechtel, and we'll say Dr. Rothermel as a second. All in favor, voice vote? Aye?
Aye.
Aye.
Thank you. All opposed?
Aye.
Thank you. We'll turn to the reports and recommendations, please. Has each member of the board received, read, and considered the hearing record, the findings of fact, conclusions, and proposed orders, and any objections filed in the matters of Tricia Annette Doran, MD, Marissa Maya Mertz, MD, and Vernon Proctor, MD? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Jackalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgen,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Further, does each member of the board understand that the board's disciplinary guidelines do not limit any sanction to be imposed, and that the range of sanctions available in each matter runs from dismissal to permanent revocation or permanent denial? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Jackalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgen,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Does each member of the board understand that in each matter eligible for a fine, the board's fining guidelines allow for imposition of the range of civil penalties from no fine to the statutory maximum amount of $20,000? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Jackalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgen,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel, Dr. Bechtel,
Yes.
thank you, and myself, Michael Schottenstein, yes.
Yes.
In accordance with the provision in Ohio Revised Code 4731.22F2 specifying that no member of the board who supervises the investigation of a case shall participate in further adjudication of the case, the secretary and supervising member must abstain from further participation in the adjudication of any disciplinary matters. In the disciplinary matters before the board today, Dr. Rothermel served as secretary and Dr. Safran served as supervising member. In addition, Dr. Bechtel served as secretary and or supervising member in the matter of Dr. Doran. During these proceedings, no oral motions may be made by either party. Finally, respondents and their attorneys addressing the board will be allotted 5 minutes to do so. The board parliamentarian will advise when the 5 minutes has expired. The assistant attorneys general will be subject to the same limitations. The respondents and their attorneys are still viewing the meeting remotely and have a number to call in the event of an emergency or procedural concern. Please turn to the matter of Tricia Annette Doran, MD. Objections have been filed and were previously distributed to board members. Mr. Porter was the hearing examiner. A request to address the board has been filed on behalf of Dr. Doran. 5 minutes will be allowed for that address.
Morning. Before we begin the address, Dr. Schottenstein, I'd like to make sure that my client who is logged in is able to communicate. I think when we were testing before, we couldn't hear her. Dr. Doran,
Oh, yes. Yes, I'm here.
okay, can you hear everything okay?
I can hear you. I guess you can hear me too. Is that okay?
And I see Dr. Schottenstein's nodding his head, so I think everyone else can hear you too.
Yes.
Okay, great.
Yeah.
Okay, great. Thanks.
Okay, with that, I'll begin. Board members, thank you very much. My name is Eric Plinke. I am here today visually on behalf of Dr. Doran to address the R&R that's before you. This is a VA termination case, which these are rare and they're a little unusual because they always present some record difficulties. So bear in mind when you're reviewing this, it's not a medical records review case. There are not medical records before you. So in that respect, it is not a minimum standard case. Dr. Doran will address you here shortly. I'll turn it over to her, but I did just want to make two observations for you to consider. One, I think this case is similar to the Dr. Khanna case, which you had many years ago, which has a lot of similarities of an employment relationship that becomes fractured, and various allegations clinically. And in that case, I think the allegations were a little more varied and broader here with one case. But given the similarities of Dr. Khanna's case, I think a similar outcome is warranted, as Mr. Porter has recommended, because this case also have all the hallmarks of really an employment relationship that has gone bad. We have many years of performance evaluations, reviews, and clinical data to support what the evaluation stated, that she's an outstanding physician, that she performed at a very high level. Record supports that there was friction in the relationship with her supervisor. The supervisor is the one who made the initial charges against her. And then after the termination event, she takes a position elsewhere, is credentialed, makes all disclosures. In fact, it was one of her experts that hired her, which I think says a lot. And again, we see a resumption of a high level of clinical performance and good outcomes. I think makes a record that, as Mr. Porter said, this event, the criticisms related to it are an aberration or not reflective of clinical skills. I think the outcome here should reflect that. So I'll turn the remainder of the time over to Dr. Doran.
Okay, thanks. I'll try to talk fast. Okay. So I agree with Dr. Porter as well that the VA's action of revoking my privileges is an aberration and does not represent my medical abilities. Specifically, the evidence proves that during my 6+ years at the local VA, I provided excellent, very safe patient care. In 2014, my supervisor started treating me differently, and I was actively opposing his unfair treatment at that time. This caused significant friction between us, and this resulted in him looking for an opportunity to force me out of the VA, in my belief. In 2015, one of my patients experienced a sedation reaction. This patient became stiff after receiving sedation, and that reaction only happens with rigid chest syndrome. This is an idiopathic reaction that could have and normally would have been quickly and completely reversed within seconds. But in this instance, the VA had recently changed the location of the reversal agents. This created a significant delay in the rescue efforts by me and the nursing team. I preemptively called a code blue and attended to the patient while the nurses were obtaining the reversal medications from the locked Pyxis. Upon arrival, the code blue team took over the patient's care. They told the room not to administer the Narcan I had ordered, and instead the patient was intubated, but he was stable. The intubation is what actually required the patient to be transferred to an outside non-VA hospital. My supervisor at that time took advantage of the hospitalization and initiated a suspension against me, despite him agreeing there was no issues previous to this date with my clinical skills or my patient safety record. He made multiple additional allegations against me that were not sustained. I also had many outside hospitals, including another VA GI supervisor, that all supported my care decisions. The employment relationship between me and my supervisor at that point was not retrievable, and the VA agreed to remove me. They revoked my privileges in the process. As to this patient, I did visit him in the outside hospital a day or two later. At that time, he was alert, he was eating, he was, smiling. He said he was ready to be discharged to go home soon. At that point, he had no sustained damage or injury. But then a few days later, he experienced other issues at the hospital that were not related to his care at the VA. And those episodes necessitated a longer stay. So in summary, due to this patient's noticeable rigidity after receiving sedation, I believe he experienced rigid chest syndrome. This is an unexpected and idiopathic reaction. For that patient, I did use a standard weight-based sedation dose that he himself received, the same exact dose on multiple other occasions without any incident. I disagree that this one sedation reaction should have resulted in the revocation of my privileges. Regardless of the impropriety of the VA's actions against me, a patient was harmed, and for that, I forever will be deeply regretful for his harm.
Dr. Duran, I'm sorry, this is the board parliamentarian. Your 5 minutes has expired. Could you please conclude your thoughts?
Okay, thank you.
All right, thank you very much.
Okay.
Does the Assistant Attorney General wish to respond?
I do. Thank you, Mr. President. Good morning, board members. The facts in this matter are clear from the documentation provided in the hearing record. Dr. Doran had her VA clinical privileges summarily suspended and revoked in a formal action where she was notified of the allegations against her and given due process. The VA has determined that Dr. Doran erred in the treatment of one patient in January of 2015, and that approximately 6 weeks later, she inappropriately documented in the patient's record that she made a verbal order for Narcan. Dr. Doran has continued to dispute those determinations. However, the evidence is clear that those determinations were made and were subsequently upheld following an appeal process that included multiple layers of review. Pursuant to 4731-22-B24, the board is statutorily authorized to pursue discipline when a physician's clinical privileges are revoked or terminated by the United States Department of Veterans Affairs. I don't believe these cases are rare. I think in my career with the board, we've had several of these VA cases that have gone before the board. I think the record is clear. I think what the board has to consider here is Dr. Doran has continually refused to accept responsibility, and she has continued to attempt to relitigate the issues that the VA determined, and she also appealed and had determinations upholding the VA's revocation. So the board has to look at the aggravating and mitigating factors. I think failure to accept responsibility is an aggravating factor, as well as the vulnerability of the patient and refusal to acknowledge the wrongful nature of conduct. I would agree with Mr. Porter in his report in that there were no other, I guess, information that the board received that she had had any similar type incidents. I do believe that he did a thorough review of this case, and I think the board will have to determine whether, those aggravating factors would require anything other than the reprimand that he has proposed. Thank you.
Thank you. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Doran?
So moved.
Sorry, that was...
So moved, Dr. Cacarella.
Oh, Dr. Cacarella, and is there a second?
Second, Dr. Johnson.
Dr. Johnson, thank you so much. I will now entertain discussion concerning the matter of Dr. Doran. Is there any discussion? So, this is a bootstrap. It's not an occasion to relitigate the validity of the actions of the VA. It's not an occasion to weigh in regarding the doctor's opinion that the VA has been unfair to her. And it's also not a minimal standards case where we assess whether the doctor's practice of medicine fell within the standard of care. This is a case of mitigation. The state has shown, and the doctor acknowledged in testimony, that her privileges were in fact revoked by the Chalmers P. Wiley VA Ambulatory Center. That triggers disciplinary action against the doctor's license pursuant to 4731.22B24. The board has the right to discipline the doctor based solely on the B24 violation, so I'm confining myself to consideration of possible aggravating or mitigating circumstances so as to avoid any procedural due process issues. I do appreciate the distinction that defense counsel is making between employment action and the B24 violation, and much was made in the record, in the transcript, of the defense counsel's concern that the medical board, in its good faith effort to obtain information that was not relevant to the peer review process, may have erroneously been provided such information by the VA. That's actually a distinct possibility, because either the VA made a mistake in releasing some of its information used by the state, or the hearing examiner made a mistake by interpreting the material as peer review. Personally, I don't think the hearing examiner made a mistake. I also appreciate the hearing examiner's ruling which is that now that the board has been given this information, we're entitled to consider it, and that based on the fact that it's been released to us, it's by definition no longer considered protected under the peer review process. At the same time, it doesn't quite sit right with me that we're entitled to consider information that should not have been released to us in the first place, because I want to be fair to the doctor. So I guess what I would say is that for me, in trying to be fair about this, I feel like I can base my opinion regarding this matter on two main sources of information that I think are relatively non-controversial. The licensure application, in which the doctor did in fact check yes to the questions regarding a loss of privilege, and the transcript of the doctor's testimony during the hearing in which she admitted that her privileges were indeed revoked by the VA. I really think that's all we need to take action. It sort of gets us where we want to go. And so I would say that the exhibits to which defense counsel has objection don't substantially inform my opinion regarding this matter. They more corroborate it. I think that the licensure application and the testimony by themselves are sufficient for me to form an opinion regarding this matter. And so I do have the sense that this matter that we're addressing today is not representative of the doctor's career as a whole. The doctor did have excellent performance reviews during her time at the VA from 2008 through 2013. She does have good reviews from her current employer, and her colleagues refer their complex patients to her because she has such a good safety record. I think that is substantially mitigating. I think that other mitigating factors include the absence of a prior disciplinary record, the absence of a dishonest or selfish motive. It appears this is an isolated incident that's unlikely to recur. She's made full and free disclosure to the board, and she did not try to use the confidentiality inherent in the VA peer review process as a shield regarding her behavior when she was answering her licensure renewal questions. So I think the proposed order for a reprimand is appropriate, and I agree with it. Is there further discussion? Mr. Giacalone, hi.
Yeah, I would agree with Dr. Schottenstein. I think this physician really has an immaculate track record up until this point. I think, again, I'm not a physician, but the steps she took, at least in the explanation, again, I'm not looking to relitigate it, seemed to make sense, especially with the issue with the Pyxis machine and changing where it is and the accessing Narcan make perfect sense as to why there might be an issue. Again, not trying to relitigate it because that's not the purpose here. But I would agree. I think that the decision makes sense. I think the actions of the physician in the overall context makes sense. So I think the proposal for reprimand, no fine, is probably the appropriate way to go. Thank you.
Thank you, Dr. Feibel.
Yes, thank you.
Mr. Chairman.
Oh, go ahead, Betty. You want to talk?
I'll defer to you first, and then I'll be glad to.
Okay, sorry, thank you. I struggle with this case. I agree with a lot of what, most of what Dr. Schottenstein and Mr. Giacalone said. I struggle that this is one incident and the doctor has a perfect track record after that. And while we can't relitigate what the VA did, I do think there are times when people are treated unfairly by institutions, and the institutions don't always get it right. And so I think those are mitigating issues. And just because it is a bootstrap action doesn't mean we have to reprimand, I don't believe. I believe we can say, yes, this is a bootstrap action, but given all the mitigating circumstances, we can offer her no disciplinary action for this, if I'm not mistaken. So unless I'm one of the newer board members, obviously, but unless I'm mistaken, this hasn't come up, but unless I'm mistaken, I would try to support no action being taken against the doctor's license at all, even though we can do it and we're legally authorized to do it. The mitigating circumstances in this situation are too great for me to say one incident should allow a reprimand to go on a doctor's license with all the mitigating circumstances.
Thanks, Dr. Feibel. Are you making a motion for that amendment then, for no further action?
I mean, I would like to hear what everyone else said, but I'd be happy to entertain that motion if there's support for it.
Okay, so we'll get a little more feedback. Ms. Montgomery, please.
Mr. Chairman, I have I have to agree with Dr. Feibel. I'm troubled by the case, and we strive for perfection in everything we do as a professionals, but I'm troubled by the reprimand of this, if with this doctor, in that we don't have a history that tells us that it's warranted other than the bootstrap action. And albeit we can't go back and relitigate, it seems to me that we would be more just in this instance to, she's gone through the process, the organizational process, which is obviously carries not only a cost emotionally, but financially. And I frankly think wherever the facts lie, I think she's sufficiently been made aware of any deficiencies she may or may not have had. And frankly, I would like to join with Dr. Feibel in no reprimand, a recommendation for no reprimand. If he makes that motion, I will second it.
Thank you, Ms. Montgomery. Is there further discussion? Is Dr. Soin has his hand up? Hi.
Yes, thank you. Thank you so much. I also support no further action in this case, and I'm glad that it was brought up. And I do not want to relitigate the case, but I do want to explain something because I think it's important for people to understand. So look, this is one case. It's an isolated case, and the scenario in which it happened to me seems absolutely reasonable and likely that it could happen to anyone. As an anesthesiologist myself who does a lot of sedation, handling cases in rigid chest syndrome, and otherwise cases where patients are over-sedated and they start to desaturate. Things happen very rapidly. It's incredibly scary, and you have to have all materials available at all times. However, something has happened over the past 10 years due to compliance with medications that they're now locking medications, putting them in Pyxis and putting them in locations where we don't have access to them. And sometimes these happen to us without our knowledge. In other words, we'll enter a room and we have no idea where the medications are, or they're locked in a Pyxis that we don't have access to. So while we're trying to take care of a patient and all this stuff is happening and things are going crazy, we now have to find this medicine somewhere. And you heard that statement echoed to her. And we've also heard this come up a number of times as we're going through some of our rulemaking processes that we have recently. So I just think that this is a very difficult situation. I don't think this physician's nefarious. I don't think that she's trying to do anything to harm patients. I don't think she represents a harm to the public in the future going forward. I think that she was stuck in a very difficult situation, which to me seems likely that it was more of a process issue and not necessarily a patient care issue, though I realize I'm speculating and I realize I'm relitigating the case, but I'm trying to put myself in that physician's shoes. She has already suffered. She has lost privileges. She's here in front of the medical board today. I can't imagine how stressful that must be for her. So if you want to punish her, guess what? It's already been done. If you want to punish her for the sake of punishing her, I don't understand what we're gaining with that. I strongly support no reprimand and no further action. Thank you.
Thank you so much for your thoughtful comments. Any other further discussion?
I'll be happy to make a
Coccarella.
motion. Oh, sorry.
Oh, sorry. Dr. Coccarella, I just hand up.
Yeah, I just wanted to echo what Dr. Soin said. This seems more like a systems problem. And, you know, being someone who has to intubate people in emergent situations, it does happen where, you know, whether it's equipment or particularly, you know, pharmaceutical agents, sometimes they're what you need at the time that you need them, which is in terms of immediacy, they're not available to you. And you don't have any other recourse but to do what you can best, and sometimes it does affect outcomes. So I want to thank everyone for their comments and for Dr. Feibel for broaching the subject, and hopefully we can bring a motion, because I would agree with no reprimand at this time.
Thank you so much, Dr. Caraccolo. So, Dr. Feibel, do you want to go ahead and make that motion then? For
Sure. I will make a motion that we take no further action on Dr. Doran's license.
Thank you. Is there a second? Dr. Coccarella, thank you. Is there further discussion? Okay, let's have a roll call vote, please, on the amendment. Dr. Rothermel. Dr. Rothermel.
Abstain.
Thank you. Dr. Safran.
Abstain.
Mr. Giacalone.
Yes.
Dr. Sohn,
Yes.
Dr. Edgen,
Abstain.
Dr. Johnson,
Yes.
Dr. Kakarala,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Do I hear a motion to approve and confirm the proposed findings of fact, conclusions, and order as amended in the matter of Dr. Doran?
So made.
Dr. Feibel
Second.
and Dr. Sohn, thank you. Before voting on the motion to approve and confirm as amended, is there any further discussion? Okay, roll call,
Dr.
please.
Schottenstein,
Oh, forgive me, Dr. Bechtel.
I don't know
Yes.
if you could hear me, but I have to abstain on that, on the Dr. Doran's.
Thank you so much, Dr. Bechtel. We'll make sure and note that in the record. Roll call then, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgen,
Abstain.
Dr. Johnson,
Yes.
Dr. Kakarala,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Abstain.
and myself, Michael Schottenstein, yes. Thank you. Please turn to the matter of Marissa Maya Mertz, MD. Objections have been filed and were previously distributed to board members. Ms. Szymanski was the hearing examiner. A request to address the board has been filed on behalf of Dr. Mertz. 5 minutes will be allowed for that address.
Good morning. Thank you for your time. Obviously, Dr. Mertz is not with me today, and I haven't spoke to her in some time. As you probably saw from the hearing record, no one was able to contact her regarding this matter. With that in mind, I proceeded in what I thought was her best interest, and that's why I'm here today. We would like the board to consider adopting the recommendation of the hearing examiner and revoking her license, but not permanently. I would like to ask that she be given the opportunity to come back and seek reinstatement somewhere down the road. Obviously, she's not in a position to argue for her medical license right now, but as I said at the hearing, what we do know is that people can and do recover from substance abuse and mental health issues. And in the event that that happens here, I think she should be given the opportunity to come back and seek reinstatement and show this board that she's worthy of her license. One amendment I would ask to the board's or the report and recommendation is that the fine that was ordered not be due immediately and be due upon her seeking reinstatement. A couple reasons. One, I don't think she will even get notice that the fine is due, which would put her in a violation and start this process all over again. So I think it would be fair to have that fine due when she comes back for reinstatement. Thank you.
Thank you so much. Does the Assistant Attorney General wish to respond?
Just really briefly, I think the hearing examiner's report and recommendation is appropriate. I think we can all say that we hope that Dr. Mertz does, get her act together and at some point, attains sobriety and is able to perhaps pursue medicine again. So he's obviously not in that position now. As far as the fine, I think the revocation is fine. That is a proper recommendation. The fine, I mean, I don't think someone in her position is going to be able to pay a fine, quite frankly. It wouldn't be, I wouldn't be upset if the fine was eliminated from this order. And that's all I have to say. Thank you.
Thank you so much. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Mertz?
Move.
Motion, please.
So moved.
Mr. Giacalone, Dr. Johnson, thank you so much. I will now entertain discussion concerning the matter of Dr. Mertz. Is there any discussion? So I think that the doctor's not.
I'm sorry, Dr. Schottenstein, Dr. Feivel had his hand raised.
Forgive me.
Go ahead, Dr. Schottenstein, you're fine. Go ahead.
Oh, no, Dr. Feivel, please.
I was just going to say that I agree with Respondents Council and Mr. Wilcox. And I think this is a really sad situation, and I respect Mr. Newkirk for being here to represent her today. I agree with amending the order to take away the fine completely. I don't think it serves any purpose in this case, and if she is in fact able to be reinstated, I don't think we want to put any added pressure on her during that time to do so. So I would vote to revoke the fine, to remove the fine from the proposed order and just make it a simple revocation.
Okay, so Dr. Feivel's making a motion. Is there a second?
Second.
For that amended? Dr. Coccarella, thank you. And Mr. Giacalone, you had your hand up.
Yeah, I would agree with Dr. Feigl. I think the fine makes a lot of sense. This person appears to be a heroin addict. She's in a battle to begin with. I don't think we need to pile on. I think that's it.
Thank you so much. Further discussion? So I would just concur with what everybody said. Sorry?
Dr. Schottenstein?
Oh, Ms. Montgomery, yes, of course.
Yes, I want to personally thank Mr. Newkirk. He has been a remarkable representative to his client when she wasn't around and not responsive. And and with all due respect, you represent the best of this office of the profession to be able to continue to do this in light of your client's absence and obvious need. And I was also concur that we should remove the fine. This is the last thing we need to worry about with this woman. We need to rescue her, not bury her in another fine.
I agree. Thank you so much. And I'll just say, Mr. Newkirk, FYI going forward, first of all, I certainly appreciate your service to your client. But just FYI going forward, the board's not able to put conditions on future license applications. So I appreciate your thought about, moving the fine forward until such time as she would reapply, but it's just not something we're capable of doing. So really the right thing is to simply forego the fine. Sure. Any further discussion in this matter? So we've got a motion and a second on the amendment to forego the fine. Is there any further discussion? May we have a roll call, please, then, on the amendment? Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Giacalone?
Yes.
Dr. Sohn?
Yes.
Dr. Edgen?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarella?
Yes.
Mr. Gandadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Do I hear a motion to approve and confirm the proposed findings of fact, conclusions, and order as amended in the matter of Dr. Mertz? Motion?
So moved.
Second.
Sorry, Dr. Bechtel and
Second.
I'm sorry, Mr. Giacalone, thank you. Before voting on the motion to approve and confirm as amended, is there any further discussion? Roll call, please. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Giacalone?
Yes.
Dr. Sohn?
Yes.
Dr. Edgen?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarella?
Yes.
Mr. Gandadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Thank you. Please turn to the matter of zoning factor MD No objections have been filed. Mr. Porter was the hearing examiner. A request to address the board has been filed on behalf of Dr. Proctor. 5 minutes will be allowed for that address.
I'm able to talk right now?
Yes, you're able to talk. You have 5 minutes to address the board, Dr. Proctor.
Okay, great. Esteemed practitioners and protectors of public health, I just wanted to put a human face on my case in Ohio. Just some background and some update. Michigan was the first Midwest state to adopt a ballot initiative for medical marijuana in 2008. 3 years later, the Attorney General in the state of Michigan decided that it was prudent to, since he couldn't stop patients from getting recommendations for medical marijuana, what he would do is he would take the doctors out who were providing the recommendations, and that's all it was, a recommendation for use. Addiction medicine was in its infancy at that point in time. All you had to do is practice with a practitioner for 1,200 hours who was board certified in addiction medicine in its infancy. Do your homework, study for the boards. I studied for the boards, I took the boards, I passed the boards in addiction medicine. In 2011, when the Attorney General in the state of Michigan came after me, it took me 3 years to find out what the allegations were, because the allegations were internally generated. The interesting thing about addiction medicine, which I think you guys understand, is that you're working with a patient population which is basically criminal because they practice to deceive. It's a defense mechanism. It's something that they do. And it's just the way things are in addiction medicines. And I've had colleagues who have gone to jail, who have committed suicide, and not because they're bad people, but because when you're dealing with an addiction medicine population, there's a lot of things as people that we normally deal with. We expect people to tell us the truth and tell us what's going on. And when we don't know what's going on, we make decisions based on what we think. And until we can get more information on that patient in order for us to address the patient's concerns properly. An interesting thing about when I first started working in addiction medicine, I worked for an addiction medicine practice and they closed. And as a result of them closing, when the state came after records that I did not possess personally because the practice possessed them, there was a problem with me getting the records because they were in storage, and it was just a real complicated thing. So when you look at the fact that Dr. Proctor didn't have records, he couldn't find records, he couldn't submit records, that in fact is initially what's going on. So now getting back to an update on what's going on, most of the actions that have been taken against my license in Ohio, Florida, and New York are all reciprocal actions based on what Michigan is doing. And we're still in the process of trying to work that out since 2000, and it started in 2011, but the sanctions started in about 3 years ago. So we're still waiting for it to move the reinstatement with the Board of Medicine and the Board of Pharmacy. I've completed the probationary period. We've had the administrative hearings, but because the state has been shut down since March 16th, we're still waiting on some rulings. Let's see, there's a couple of more things. The Board of Medicine basically restricted my ability to write recommendations for medical marijuana. If you look back in my history, you'll see that I did a residency in obstetrics and gynecology and a residency in preventive medicine. So this whole holistic approach to letting patients manage their own problems and educating them about what the positive benefits and things are of them doing that is what holistic medicine is all about. My suspension in Michigan expires. It expired a year ago. Then they put another suspension on that expires next month. Let's see. So there's ongoing things that are still ongoing, and it seems like this is so buried in the Attorney General's office that nobody can seem to stop the train that's going on. But if you look back in the history, you'll see that basically I graduated from medical school in 1992. and finished the 2 residencies in 2000. And so for the last 20 years, I've been practicing medicine. So it gets really complicated, but it looks like that with what's going on right now, I might be only able to practice in Ohio as things are going on, because the other states have been very punitive as far as how they have addressed what's going on in Michigan, and it's still ongoing, and it's still a big problem. But
I'm sorry, Dr. Proctor.
Yes.
I'm sorry, Dr. Proctor. This is the board parliamentarian. Your 5 minutes has expired. So could you please conclude your thoughts?
Okay, so I think that for most of you physicians that know anybody who practices addiction medicine, you realize that it's a very complicated field, because you're dealing with people who practice to deceive, and you get caught up in the things that they have going on when they come after you. So that's just me just putting a human face on what you've already read and what you've already seen, to give you some backdrop as to why I'm still struggling with the state of Michigan. Thank you.
Thank you so much. Does the Assistant Attorney General wish to respond? Hello?
Hi, this is Kim. The YouTube live stream has stopped at this point. So if we could just pause for a minute in the meeting until we're able to get that back up.
Thank
you. If you could, I'd appreciate that. Thank you.
Of course.
Dr. Schottenstein?
Yes.
Hi. There's a lot of feedback. I wonder if everyone not speaking could mute their mic. Thanks.
Thank you for the suggestion.
All right, we are back up, so we can proceed. Thank you.
Thank you so much, Kim. Does the Assistant Attorney General wish to respond?
No, the state does not wish to respond. Thank you.
Thank you. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Proctor? Motion? Dr. Bechtel, thank you. Dr. Sohn, thank you. I will now entertain discussion concerning the matter of Dr. Proctor. Is there any discussion? So,
Dr. Schottenstein?
Yes. Yes. So
I don't know. I can you see me?
Yeah.
I think if you look at this case, there's obvious. As a former prosecutor, you look at this and you're looking at an anxious investigation that it doesn't look as if they've put their case together well. The ALJ found on numerous accusations not proven, and then there's a discussion between the ALJ and the board in terms of seeking to at least find something. So there's a sense of anxiety that runs throughout this, as if they're anxious to get this doctor in a way and continue to look for cases or ways in which to find some problems, and frankly, some of what the board seems in Michigan to have done looks like they're minor. We will. I don't mean to minimize, but that given what the allegation is, the finding of the board is, well, we agree that the documentation is bad. It does sound as if the documentation, at the very least, is bad, and I would be very interested in what Dr. Soin would say, particularly since he deals in this area, as to the treatment, because I think Dr. Proctor at least does indicate this was an evolving. We were all learning about how best to handle this. My feeling is personally that the reprimand, the proposal is I could concur in it, but I have to say to you, it really does feel as if bending in this situation that this was not an ideal investigation and not an ideal presentation underlying all of this. Nevertheless, you do have an appropriate establishment by the Attorney General's office that there is a bootstrap, and I think a reprimand would be appropriate.
Thank you, Ms. Montgomery. Is there further discussion?
Yeah, hi, everyone. Thank you, Betty. I'm happy to weigh in an opinion on some aspects of this particular case because I can sympathize with Dr. Proctor on a couple of issues, going through the process in Ohio, but also casually observing what's happening in Michigan, and that is regarding marijuana, medical marijuana, its use, the rules and regulations behind it seem to have been a moving target. And, you know, you hear different things, you see different things, and you see different rules and laws and regulations passed, and it's kind of hard to keep track of all the evidence on what you can do and what you can't do, and also the evidence that's accurate and fair in terms of what's effective in these scenarios. And, you know, I'm on these commissions for the state, and many times, and I feel like I have a lot of information personally, and many times I have to check to understand where we're at. And so I couldn't imagine just being like a private practitioner or physician out there trying to navigate through these waters without all the access that even I have to some information. So to that extent, I do sympathize with the statements that Dr. Proctor made on how it is a complicated issue. Thank you.
Thank you, Dr. Swan. Further discussion? So, yeah, this is a bootstrap, right? And so the Michigan Medical Board and Pharmacy Board did in fact take action against Dr. Proctor's license based on minimal standards concerns. You know, for the State Medical Board of Ohio, it's not a minimal standards case. You know, I feel like I can say in general that I understand why the Michigan Medical Board took action. You know, I appreciate Ms. Montgomery's thoughts and Dr. Sowen's thoughts. I felt like there were some legitimate concerns about prescribing patterns and documentation. And so in that respect, I feel like the proposed order is fair. You know, it gives a reprimand as well as probation for a few years and compliance with the Michigan Medical and Pharmacy Board orders, controlled substance prescribing course, medical records course, and a practice plan. I think the proposed order is fair to the doctor, and I think it protects the citizens of Ohio. Is there further discussion? Dr. Feibel, hi.
Yeah, thank you. I struggle with this as well. I feel very much the way Dr. Schottenstein does. I'm a little concerned, and I don't know if we can do this or not, but can we limit his controlled substance prescribing? And is that part of that's part of the Michigan order, correct?
Correct.
Is that, yeah. And are we able to make that part of our order as well?
So that limitation, if I'm recalling correctly, of the Michigan order was time limited. So we certainly are able to amend the order to, you know, to amend it in such a way as to limit the prescribing of controlled substances. But that was part of the Michigan's initial part of their order that had an expiration on it after, I want to say, a year or so. Further discussion? Mr. Giacolone.
Okay.
Yeah, you know, I looked at this too, and I mean, when I broke it down, there were three significant issues that really brought this person to the forefront, right? He signed a medical marijuana certificate without a face-to-face encounter. We got prescribed controlled substance in Michigan while only having a DA registration in his New York office, and the methadone issue, where there's a question whether he tried to wean somebody down on methadone and gave him Suboxone. I don't see those as big ticket items, but the thing that kind of bothers me is the comments he made just recently about, well, I always have to trust my patients, and you know, I kind of go with it. My only concern is we're dealing with addicts, and they're not trustworthy, and to take kind of this, you know, accept them at face value is a bit puzzling to me in terms of that commentary. So I was right along with everybody until unfortunately he spoke, and it made me take me aback. Is kind of like, well, that's just, to me, that could be a nice excuse for when you just want to stick your head in the ground. And I hope that's not the case here, but it is a puzzlement in terms of that statement that bothered me. So I could live with the proposal. I think that the issue with the substance limitation is, as Dr. Schottenstein pointed out, it was limited to 1 year, and that door in Michigan kind of closed. So, I mean, I guess we could add another year here if that makes sense. But that essentially cuts off any of his addiction process. He ain't gonna be able to try Suboxone, nothing. So this is going to be a problem if he wants to continue his addiction practice here. So, you know, we may benefit one side and hurt the other if we want to continue addiction practice. So I'm kind of stuck with, you know, where does that leave us? I might just simply go with what we got, but just a caution to the doctor if he gets through this, that taking people at face value that have addiction issues is troublesome and will get him further down this hole if that's the process he's going to adopt going forward, especially in Ohio. Thank you.
Thank you, Mr. Giacalone. Is there further discussion? Dr. Feibel?
Yeah, I just wanted to add to that. It does make me nervous that we'd be the only state that he can effectively practice in. If we don't put some parameters, good parameters around it, and something happens, I think the citizens of Ohio potentially could be upset with us that we didn't do more to protect them. And again, that is our job, is to protect the citizens of Ohio from any harm. So again, I'm still uncomfortable with his prescribing practices, and I realize the issues surrounding them that everyone's brought up, but I do worry about being the only state that he can really practice addiction medicine in. So I'm concerned about not limiting his controlled substance prescribing.
And Dr. Bechtel, you've had your hand up.
Yes, I just wanted to comment. The proposed order has two important components. I think that's the medical records course, and then also the prescribing course. It'd be really critical for him to make sure we follow through on that. Because if you look at medical documentation, that's been a major concern in the records that are reviewed. I think the proposed order is a good one.
Thank you, Dr. Bechtel. Ms. Montgomery.
Dr. Schottenstein, if part of the order also, part of the recommendation tells us that the exact number of hours that are required with regard to the prescribing courses and addiction, CMEs, etc. I don't know how usual that is, and who makes the decision on the number of hours, since it's not. We are not approving a set number of hours. How does that go to our supervising? Does that go to where does that? How does that occur?
Right. So the controlled substance and documentation courses are first weighed in on by the secretary and the supervising member. They either agree that the courses are, you know, legitimate and reasonable, or they disagree. And then that recommendation, either for or against, comes to the full board as a probationary request to have those courses approved. And so we would ultimately have the final say in terms of approving those courses or not. You know, if the secretary and supervising member disagree, then we would know that. And those courses also do not count in terms of the total number of CME that are otherwise required.
Yeah. What I wasn't clear on is who makes the decision on the number of hours, not approving the courses, but we don't have a recommendation on how many hours of education outside of the normal CMEs. And then that comes through the secretary and supervising folks,
Yeah,
members.
In other words, we don't have a set number of CME, but we have essentially our standards as to what we conceptualize as a legitimate course.
Okay, thank you.
Of course. Is there further discussion? Mr. Jekyll, your hand is up, I think.
Well, actually, Dr. Feigl had his hand up first.
Dr. Feigl, if you'd be so kind.
I'm sorry. I just one more thing is if we're not going to limit his controlled substance prescribing, I would at least recommend that he, prior to his license being freely able to practice in Ohio, that the controlled substance course and the medical records course be completed before you start practice at least. I mean, to wait a year and potentially have him misprescribe or do things like that for a year doesn't seem right to me. So if at the very least, that's the minimum I will support in this order, is to have that done ahead of time prior to him commencing practice in Ohio.
Okay, thank you. And I'll just point out too, Dr. Feigl, that the doctor will be in a practice plan if he chooses to practice in Ohio. So his practice will be, thoroughly monitored by the board. And I certainly appreciate your thought about the timing of the controlled substance and medical records courses. Right now, I think that, looking at the order, I don't know that the way it's worded is that the controlled substance and documentation courses have to be done prior to practicing in Ohio. Kim, can you speak to that if you're there? Is Kim with us? No? Okay. Is there further discussion? Okay.
There's Dr. Soin.
Yes, hi. Yes,
you.
hello. Hi, everyone. I just want to point out, I actually really agree with Dr. Feigl's points and sentiments. I think they're very important and well taken, and something worth discussing because, the state of Ohio regarding our prescription algorithms and guidelines and with controlled substances and even medical marijuana, do vary from state to state. And, I would argue that there are instances where we're rather stringent on things. So it's very important for Dr. Proctor to complete those courses and maintain the practice plan because, I'd hate to see him end up in a situation again. And I don't know how to mitigate that issue of concern, barring some sort of suspension until he completes the courses. I don't know how to achieve Dr. Feigl's goal, but I do appreciate his comments, and I would like to understand if there is a way to help satisfy his concerns.
I think part of the issue is that the doctor's license is currently active, right? And so if we're going with a reprimand, essentially he's already, able to practice. And so I don't think we can, I think it would be challenging to put a condition of some sort, in terms of, fulfilling the obligation for the courses prior to practice. Because he has his license at this time. Sorry, was there someone jumping in?
This is Kim. I stepped out for a moment. Is there a question?
So what we had talked about was Dr. Feigl's thought that it would be reasonable if Dr. Proctor were to complete his controlled substance and documentation courses prior to practice in Ohio, but we were just sort of talking about how his license is currently active. So I'm not sure how we would word that.
Right, you would have to do a suspension with an indefinite suspension that would lift, when conditions are met, and then you would set forth what conditions you would want to have met before that suspension is lifted.
I think the order said something about refraining from practice in Ohio without our board approval. So I think that all ties in.
One thought, Michael, it might be suspend his controlled substance prescribing until he completes the course, if that's where we're going. So we can still practice.
Courses have been completed.
Substance piece is suspended until he completes the courses might be an option as opposed to suspending it for everything. And that's really what you're trying to get to anyways.
Fair enough. Good
The
thought.
courses have
Further
been
discussion?
completed.
Sorry. Ms. Montgomery?
Dr. Proctor
Courses.
has indicated that courses are already completed.
It was a requirement by the state of Michigan, and I had to submit the documentation and the controlled substance CMEs to the state of Michigan, and it was approved already. So that corrective action has already been performed and completed in the state of Michigan.
Well, so I guess that begs the question, though, as to whether or not we wanted, the doctor to take essentially our recommended courses as well, or if we are content essentially with allowing the Michigan courses to suffice. Is there further discussion? Okay. Did anyone have a motion for an amendment based on the different ideas that we've heard today in our discussion? Or shall we just go ahead and vote on the order? Dr. Feibel.
I will make an amendment that prior to Dr. Proctor being able to prescribe controlled substances in the state of Ohio, that he complete an approved course in the state of Ohio for controlled substances and medical records both.
Thank you. And so in that respect, thank you so much. And so then we're talking about the indefinite suspension with the suspension resolving when the courses are completed.
I was taking Mr. Giacalone's approach and making it just for controlled substances. So we allow him to practice, but not prescribe controlled substances in the state until he completes an approved course in the state of controlled substances, uncontrolled substances, and medical records.
Okay.
And I also am worried a little bit. I also am a little worried about Betty's point about the time frame. I think that's very. I am not clear really who approves how much time he needs. That would seem like it would be part of the order to me. But again, I don't know how this works exactly.
I'm sorry to interrupt you, Dr. Schott. Did you second Dr. Feibel's motion to amend, Dr. Bechtel? Did I catch that correctly? Okay, very good. Thank you.
Dr. Bechtel second.
May I comment on Dr. Feibel's? It would seem to me that if we have deferred to the secretary and the supervising member as to the number of hours, that we should be also deferring to them to say, okay, he's already taken courses. Do the courses meet sufficiency in their minds, so that we're not requiring him to have to redo something he's already done? That seems to be both expensive and unnecessary, if in fact we believe that the coursework that he's taken is sufficient to allow him to prescribe. Otherwise, then what we are essentially saying is, and let's assume that it is sufficient, but we still make him, we make him go through this. Then what we're actually saying is that we're adding a little more punitive nature to our response to him, and I share the concern because there seems to be an anxiety in Michigan, either through the investigators or the board, that there is a significant underlying problem here. But this case has been going on for years, and at some point, I think we owe, in fairness, if the courses he's taken are sufficient and a number of hours sufficient, that if there were less time taken, that would be more amenable. But now this has gone on a long time, and for lots of reasons, which hopefully we will address as we look at the way we're organizing ourselves institutionally. But I guess I would only say to Dr. Feibel, if we can confirm that what he's taken is sufficient, then I would not necessarily agree that he should take more.
So I think that the doctor will have the opportunity to make a probationary request that the courses he's already taken be considered equivalent to what we would request. The secretary and supervising member can then sort of weigh in on whether or not they approve of that request. But then again, it comes to the full board to ratify whatever the secretary and supervising decision is in that regard. Further discussion? Oh, Dr. Safran, your hand's up.
Just a point of information is that when a licensee takes a course, they have to supply.
Sorry, Dr. Safran, your mic cut out.
I'm sorry. When a licensee takes a course, we ask them for a summary of the course and how they're going to utilize the course in their practice.
Okay, thank you, Dr. Safran.
In this matter, Dr. Schottenstein.
Sorry, Ms. Anderson, yes?
Dr. Safran is a supervising member in this matter, and he is not allowed to participate in the adjudication.
Okay, thank you so much. Is there further discussion? Okay, so
Tessie just needs to.
Just one comment. I don't know the prescribing courses or whatever, but aren't they indicative of the state law in Ohio as opposed to the state law in Michigan? I mean, I haven't taken the courses, but you guys tell me if there is a nuance to Ohio where he's going to be practicing, maybe they aren't necessarily the same courses. Maybe some of it's overlapping, but there's some things in there, maybe some significant things, because obviously Dr. Proctor has had some issues with some of the finer points in prescribing and what he can do and what he can't, that maybe the prescribing course may be beneficial to him. Just a thought.
Yeah, good thought. Thank you so much. Is there further discussion? So we have an amendment before us. Maybe we can go ahead and vote on the amendment if there's no further discussion. And so again, this is an amendment to essentially restrict the license from controlled substance prescribing until such time as the controlled substance and medical records courses have been completed, right?
Ohio based was my in Ohio was the original amendment I made. Now, if that, I think we should vote on that first, and then if we want to change it to what Ms. Montgomery wants, then we can do that. But I'm pretty adamant in this situation of protecting the public that we should. I don't think an extra course is going to be an undue burden in this type of situation. I think extra education is always good, and given the situation, I think that way he will be up on Ohio laws for sure, and there will be no ambiguity. So that was my point in making that. And so I think my motion is courses in Ohio, medical records courses, and controlled prescribing courses in Ohio based.
Thank you, Dr. Feibel. Any further discussion before we vote on the amendment? Okay, let's vote. Dr. Rothermel.
Abstain.
Dr. Safran.
Abstain.
Mr. Giacalone.
Yes.
Dr. Sohn.
Yes.
Dr. Edgin.
Yes.
Dr. Johnson.
Yes.
Dr. Cacarella.
Yes.
Mr. Ganadakis.
Yes.
Ms. Montgomery.
Yes.
Dr. Feibel.
Yes.
Dr. Bechtel.
Yes.
Myself, Michael Schottenstein, yes. Do I hear a motion to approve and confirm the proposed findings of fact, conclusions, and order as amended in the matter of Dr. Proctor? Motion?
So moved.
Second.
Dr. Bechtel and
Dr. Edgin.
sorry, who was this? Dr. Edgin.
Dr.
Thank you
Edgin.
so much. Thank you. Before voting on the motion to approve and confirm as amended, is there any further discussion?
Michael, just to clarify, it's Dr. Feigel's amendment that includes all the other parameters in there about the monitoring and everything.
Thank you. That was the only amendment to the order, so the rest of the order still stands.
And I just
Thank
wanted
you so
to make
much.
sure we're on the same page. It wasn't just we're throwing off the rest of it. Okay, fine, perfect.
You're
Sorry.
very kind. No, I definitely appreciate the thought. So we'll vote. Dr. Rothermel.
Abstain.
Dr. Safran.
Abstain.
Mr. Giacalone.
Yes.
Dr. Sohn.
Yes.
Dr. Edgin.
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
myself, Michael Schottenstein, yes. Thanks, everybody. We'll turn to proposed findings and proposed orders, please. In the following matters, the board issued notices of opportunity for hearing. No timely requests for hearing were received. The matters were reviewed by a hearing examiner who prepared proposed findings and proposed orders, and they are now before the board for final disposition. These matters are disciplinary in nature, and therefore the secretary and supervising member cannot vote. In these matters, Dr. Rothermel served as secretary, Dr. Safran serves as supervising member, and Dr. Bechtel served as secretary and/or supervising member. Please turn to the matter of Muhammad Mutaz Al-Mawaldi, MD. Do I hear a motion to find that the allegations as set forth in the November 13th, 2019 Notice of Opportunity for Hearing in the matter of Dr. Al-Mawaldi have been proven to be true by preponderance of the evidence, and to adopt Ms. Lee's proposed findings and proposed order? Motion?
So moved.
Dr. Johnson and
Second.
Dr. Cacarella, thank you. I will now entertain discussion concerning the matter of Dr. Al-Mawaldi. Is there any discussion? Okay, let's have a roll call then vote, please, to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Al-Mawaldi. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgin,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Abstain.
and myself, Michael Schottenstein, yes. Thank you. Please turn to the matter of Alan Arnold Godofsky, MD. Do I hear a motion to find that the allegations as set forth in the November 13th, 2019 Notice of Opportunity for Hearing in the matter of Dr. Godofsky have been proven to be true by preponderance of the evidence, and to adopt Ms. Lee's proposed findings and proposed order? Motion?
So moved.
Second.
Dr. Edgin, Dr. Cacarella, thank you. I will now entertain discussion concerning the matter of Dr. Godofsky. Is there any discussion? Hearing none, we'll go to a roll call vote then, please, to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Godofsky. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgin,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Abstain.
and myself, Michael Schottenstein, yes. Please turn to the matter of David Blaine Harding, MD. Do I hear a motion to find that the allegations as set forth in the December 11, 2019 Notice of Opportunity for Hearing in the matter of Dr. Harding have been proven to be true by preponderance of the evidence, and to adopt Ms. Lee's proposed findings and proposed order? Motion, please.
So moved.
So moved.
Dr. Carvalho and Dr. Johnson, thank you so much. I will now entertain discussion concerning the matter of Dr. Harding. Is there any discussion? Hearing none, may we please have a roll call vote to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Harding? Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgin,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Abstain.
and myself, Michael Schottenstein, yes. We'll turn now to findings, orders, and journal entries. In the following matters, the board issued notices of opportunity for hearing, and documentation of service was received for each. There were no timely requests for hearing filed, and more than 30 days have elapsed since the mailing of the notices. These matters are therefore before the board for final disposition. These matters are non-disciplinary in nature, and therefore all board members may vote. So in the matter of Jennifer Ann Kokanowski, MT. On January 8th, 2020, the board issued a notice of opportunity for hearing to Jennifer Ann Kokosinski, MT, informing her that the State Medical Board of Ohio proposed to deny her application for a certificate to practice massage therapy because she does not hold a diploma or certificate from a school, college, or institution in another state or jurisdiction that meets the board's required course of instruction and hasn't held a current license, registration, or certificate of good standing for massage therapy in another state for at least the preceding 5 years. Do I hear a motion to find that the facts set forth in the January 8th, 2020 notice of opportunity for hearing have been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing denying Ms. Kokosinski's application? Motion?
So moved.
So moved.
Second. Dr. Safran and Ms. Montgomery? Thank you. Is there any discussion concerning the motion? Roll call, please. Dr. Rothenbaum.
I have a question.
Yes, Ms. Montgomery, sure.
She doesn't meet one of the 3 criteria. And one of them, and the last one is that she hasn't had the license in another state for 5 years. If she waited into July of 2020, could she reapply and then be granted the license?
Kim, do you want to weigh in on that?
She's just shorter. She's just short of the 5 years. She's a couple months short of the 5 years. I can't hear Kim if she's wearing.
If she meets the 5 years, then she would.
I'm sorry, what is she saying?
I think if she meets the 5-year criteria, then she would be eligible, is what I heard. Dr. Rothenbaum.
I think she has not met the requirement, the educational requirements for the hours as well.
So I have to go back to 473105. Is that of the 3 criteria, there's an or, the last criteria is or in the 5 years. You're indicating that the 5-year alone won't get her in from another state?
Joe's on the phone as well. And you may want to.
I'm sorry, I can't hear you.
So Joe, do you want to weigh in on that?
On the licensure issue?
The requirement is that you have to meet either the educational requirements or hold a license in another state for 5 years.
So if she stays, she holds that license for 5 years. By July, I think is when she'll have it for 5 years. She could reapply and then get her license.
That's correct.
Okay.
One comment.
Thank you so much.
Can we tell her that when we deny it? Can we tell her that?
Yeah, Joe, is she aware?
The only problem is that she would need to keep that active, that license valid and active. I guess we don't really know right now if she has kept that license active as of today.
Right, but my question is.
That gets to the right point that Bob is making, which is a good point. If we deny it, will we tell her?
Can we tell her that? So she knows to keep her license active if she wants to return, if she wants to come to Ohio.
I mean, we can certainly tell her that. I have no problem reaching out to that applicant and letting her know.
I'm sorry, what was that, Joe?
I can certainly reach out to the applicant and let her know.
Okay. I think that would be
helpful.
helpful.
I think that would be, I agree. I think that would be right and fair. So thank you, Ms. Montgomery, for bringing that up. Is there any further discussion? Okay. We'll take a roll call then, please, regarding the motion. Dr. Rothenbaum?
Yes.
Dr. Safran?
Yes.
Mr. Giacalone?
Yes.
Dr. Sohn?
Yes.
Dr. Edgen?
Yes.
Dr. Johnson?
Yes.
Dr. Cacarella?
Yes.
Mr. Gondadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Thank you. On January 8th, 2020, the board issued a notice of opportunity for hearing to Aurora Lee Van Norman, MT, informing her that the State Medical Board of Ohio proposed to deny her application for a certificate to practice massage therapy because she does not hold a diploma or certificate from a school, college, or institution in another state or jurisdiction that meets the board's required course of instruction and hasn't held a current license, registration, or certificate of good standing for massage therapy in another state for at least the preceding 5 years. Do I hear a motion to find that the facts set forth in the January 8th, 2020 notice of opportunity for hearing have been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing denying Ms. Van Norman's application? Motion?
So moved.
So moved.
Dr. Safran and Dr. Johnson, thank you so much. Is there a discussion? Okay, roll call please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Giacalone?
Yes.
Dr. Soen?
Yes.
Dr. Edgen?
Yes.
Dr. Johnson?
Yes.
Dr. Caccarella?
Yes.
Mr. Gondadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. On January 8th, 2020, the board issued a notice of opportunity for hearing to Lindsay Danielle Wedge, LB, informing her that the State Medical Board of Ohio proposed to deny her application for a limited permit to practice dietetics because she failed the examination given by the Commission on Dietetic Registration for registered dietitian status on 3 occasions. Do I hear a motion to find that the facts set forth in the January 8th, 2020 notice of opportunity for hearing have been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing denying Ms. Wedge's application? Motion, please.
So moved.
Dr.
So
Caccarella
moved.
and Dr. Johnson, thank you. Is there any discussion regarding the motion?
No, Michael, I just have one stupid question. Is it three times and you're out, or can she kind of take this thing ad nauseum until she passes and then we give her a license?
Okay, good question. Kim, do you know the answer to that? Or Joe?
She was ineligible. She was ineligible for the limited permit due to failing the examination twice. However, once she does pass the exam, she will be eligible for. She could be eligible for a full licensed dietitian.
Okay. So there's no limitation. You can take the exam.
No limitation in our rules about how many times you can take the examination.
Okay, thanks, Joe.
Thank you. Good thought. Is there further discussion? Okay, roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Giacalone?
Yes.
Dr. Soen?
Yes.
Dr. Edgen?
Yes.
Dr. Johnson?
Yes.
Dr. Caccarella?
Yes.
Mr. Gondadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. I will now entertain a motion to go into executive session to confer with the medical board's attorneys on matters of pending or imminent court action and for the purpose of deliberating on proposed consent agreements in the exercise of the medical board's quasi-judicial capacity. Is there a motion?
Yes. So moved.
Dr.
Edgen?
Edgen and Dr. Bechtel, thanks so much. Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Giacalone?
Yes.
Dr. Soen?
Yes.
Dr. Edgen?
Yes.
Dr. Johnson?
Yes.
Dr. Caccarella?
Yes.
Mr. Gondadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. The time is 10:42 a.m., so the board is in executive session.
If we can just please until Tessie gives us the all clear that the live stream has been killed. So please don't anybody say anything until we make sure the live stream is off. Thank you.
Thank you.
right, the live stream has ended. I'm going to stop the recording on our meeting, and then you'll be able to do it.
Where we
This
do our
conference will now
retreats,
be
we can
recorded.
easily socially distance. So it would be really nice to do a retreat, to be honest with you. We've got a lot of new things happening, and I would really like to do a in-person retreat if it's, you know, legal and if everyone thinks it's safe.
Okay, are you ready for me to start the live stream again? Right, give me 10 seconds, and then I'll run back and let you know when you're able.
Yeah.
All right, very good. We're streaming again. You're able to resume the board meeting.
Thank you. So maybe we'll go through the settlement agreements then, please. Do I hear a motion to ratify the proposed permanent surrender with GLHMD? Motion?
So moved.
Dr. Johnson and
Second.
Dr. Kakarala, thank you. Roll call, please. Dr. Rothermel?
Abstain.
Dr. Safran? Dr. Safran?
I'm sorry, abstain.
It's quite all right. Mr. Jackalone?
Yes.
Dr. Sohn?
Yes.
Dr. Edgin?
Yes.
Dr. Johnson?
Yes.
Dr. Kakarala?
Yes.
Mr. Gandadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Do I hear a motion to ratify the proposed Step 1 consent agreement with LAJPA? Motion?
Move.
So moved.
Mr. Jackalone, Dr. Johnson, thank you. Roll call, please. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Jackalone?
Yes.
Dr. Sohn?
Yes.
Dr. Edgin?
Yes.
Dr. Johnson?
Yes.
Dr. Kakarala?
Yes.
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Abstain.
And myself, Michael Schottenstein, yes. Do I hear a motion to ratify the proposed permanent surrender with JMRDO? Motion?
So
So
moved.
moved.
So moved.
Dr. Kakarala, Dr. Johnson, thank you. Roll call, please. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Jackalone?
Yes.
Dr. Sohn?
Yes.
Dr. Edgin?
Yes.
Dr. Johnson?
Yes.
Dr. Kakarala?
Yes.
Mr. Gandadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Abstain.
And myself, Michael Schottenstein, yes. Do I hear a motion to ratify the proposed Step 2 consent agreement with LSMD? Motion?
Move.
So moved.
Mr. Jackalone, Dr. Johnson, thank you. Roll call, please. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Jackalone?
Yes.
Dr. Sohn?
Yes.
Dr. Edgin?
Yes.
Dr. Johnson?
Yes.
Dr. Kakarala?
Yes.
Mr. Gandadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Do I hear a motion to ratify the proposed addendum with MMMD? Motion?
So moved.
Dr. Cacarella and
Second.
Dr. Johnson, thank you. Roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgin,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis, Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel, sorry, Dr. Bechtel.
Yes.
Oh, thank you. And myself, Michael Schottenstein, yes. Do I hear a
Yes.
motion to ratify the proposed consent agreement with RGS-DPM?
I'm sorry, Dan. Am I muted? No, I'm not muted. Dr. Beckel, could you abstain on the last one on MMMD? Yes, I'll need to abstain on the last one, yes. Excellent, thank you. Sorry to interrupt.
No worries, Ben. Thank you so much. Is there a motion for RGS-DPM?
So moved.
So moved.
Second.
Mr. Jekyll and Dr. Johnson, thank you. Roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgin,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Do I hear a motion to ratify the proposed consent agreement with BTS-DPM? Motion?
So moved.
Dr. Bechtel and
Second.
Second, Dr. Johnson, thank you. Roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgin,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Abstain.
and myself, Michael Schottenstein, yes. Do I hear a motion to ratify the proposed permanent surrender with ELSPA? Motion?
Move.
Mr. Giacalone and Dr.
Second.
Cacarella, thank you. Thank you. Roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgin,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yep.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Abstain.
and myself, Michael Schottenstein, yes. Do I hear a motion to ratify the proposed Step 1 consent agreement with JDM-MD? Motion?
So moved.
Dr. Bechtel and,
Second.
Second.
forgive me,
Second.
Dr. Edgin, thank you. Roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgin,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
And myself, Michael Schottenstein, yes. Do I hear a motion to ratify the proposed consent agreement with MCNMD? Motion?
So moved.
So moved.
Dr. Bechtel, Dr. Kakarala, thank you. Roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Soin,
Yes.
Dr. Edgin,
Yes.
Dr. Johnson,
Yes.
Dr. Kakarala,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Fibo,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Do I hear a motion to ratify the proposed permanent retirement with JCMMD? Motion?
So moved.
Dr. Kakarala and
Second.
Dr. Johnson, thank you. Roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Soin,
Yes.
Dr. Edgin,
Yes.
Dr. Johnson,
Yes.
Dr. Kakarala,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Fibo,
Yes.
Dr. Bechtel,
Abstain.
and myself, Michael Schottenstein, yes. Do I hear a motion to ratify the proposed permanent surrender with RFRMD? Motion?
So moved.
Dr.
So
Bechtel
moved.
and Dr. Johnson, thank you. Roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Soin,
Yes.
Dr. Edgin,
Yes.
Dr. Johnson,
Yes.
Dr. Kakarala,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Fibo,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. So we can move on to citations. Is everybody good? Does anybody need a break? Or are we sort of good to keep going? Okay, let's just move on then. Ms. Marshall, Chief Enforcement Attorney, will now present the proposed citations to the board, please. Hi, Rebecca.
President Schottenstein, members of the board, good afternoon, or good morning, I guess still. We have 11 proposed citations for you today. The first is to be issued to an MD. It is a minimal standard citation based on prescribing to 7 patients. Second is to be issued to an MD. It is based on action by the Virginia Medical Board regarding an inappropriate relationship with a patient. Citation number 3 is an immediate suspension. It's to be issued to a physician who recently received intervention in lieu of conviction for illegal processing. Citation number 4 is to be issued to an MD. It's a minimal standards case involving failure to employ acceptable scientific methods. Citation number 5, another minimal standards case related to prescribing, this one involving 15 patients. Citation number 6, to be issued to a massage therapist. It is based on sexual misconduct and failure to cooperate in our investigation.
Can I ask you a question about that one, or is it?
Yes.
I guess I need Kim to let me know what I can say about this before I say it. I'm worried about number 4 on the site, and again, summary suspension issues and things like the like. And I know I brought this up before, but anyone want to comment on that, or is anyone else concerned about that, or is this just a normal site?
So Rebecca, the concern is that this was not a summary suspension.
For citation number 4. Yeah.
No.
No.
Citation number 6, number 4.
I'm sorry. Citation number 6, action number 4. That those events occurred over 3 years ago. So that is why you're not seeing a summary suspension on this case. And also, although I do feel that the site is solid and obviously you'll get more information from the patient at hearing, but the attempts that we took to kind of vet that allegation in our investigation, we didn't get any information because we didn't have the cooperation. So I think it's a combination of those two things. Does that answer your question?
Yes, thank you.
You don't have the cooperation of the patient, or you have cooperation from the doc or the
we do not have the response
the
to our
LMP.
investigation from the massage therapist who was accused. We do have the cooperation of the patient.
Thank you.
Okay. Citation number 7 is to be issued to a massage therapy applicant. There were actually 2 sites on this you'll see this month. One is based on the prior revocation of her license by the nursing board. So you have the bootstrap site on that. The second is the special limited notice you get based on her failure to go to an evaluation regarding alleged impairment. Citation number 8 is to be issued to a massage therapist. This is based on violation of the probationary terms of your August 2019 order. This person is already currently suspended, if you're wondering about that one. Citation number 9 is to be issued to a massage therapist who's seeking restoration and was determined to be unable to practice currently due to schizophrenia. Citation number 10 is to be issued to an MD. This is the applicant for full licensure who failed to go to our evaluation regarding a physical condition that's impacting the ability to practice. And our final citation number 11 is the second site for the person who I told you was getting 2 sites based on not going to our exam. Thank you.
Thank you so much, Rebecca. We will be considering citation numbers 1, 3, and 5. Bechtel may abstain or vote appropriately. Would any other board member like to consider a citation separately? Do I hear a motion then to approve and issue citation number 3, an immediate suspension?
So moved.
Second.
Dr. Bechtel and
Second.
Dr. Edgen, thank you. Roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgen,
Yes.
Dr. Johnson,
Yes.
Dr. Johnson. Oh, thank you. Dr. Kakarala,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Do I hear a motion to approve and issue citation numbers 1 and 4? Motion?
So moved.
Dr. Kakarala and
Second.
Mr. Giacalone, thank you. Roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgen,
Yes.
Dr. Johnson,
Yes.
Dr. Kakarala,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Abstain.
and myself, Michael Schottenstein, yes. Do I hear a motion to approve and issue citations numbers 2 and 5 through 11? Motion?
So
So
moved.
moved.
Dr. Bechtel, Dr. Edgen, thank you. Roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgen,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Gonadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Ms. Stephanie Luca, Executive Director, will now present the operations report.
Thank you, Dr. Schottenstein.
Of course.
So, going through the report, just a quick update on human resources. We are still under the hiring freeze, and I expect that to continue for some time. Again, I think when it comes to filling of positions and what our position needs look like, that will be a conversation that we'll need to have once we get next year. We're set for this fiscal year. Next fiscal year, depending on what that guidance looks like, we'll have to determine, kind of strategically what we need for positions. And what I mean by that is, for example, let's say, God forbid, 7 investigators resign. We can't just not hire 7 investigators, even if we're on a freeze. We would have to seek some sort of exception, or we would have to make adjustments in other areas. So again, once we get final guidance for next fiscal year, we'll be talking about what staffing needs look like and what adjustments we may need to make on that front. Any questions on that hiring freeze? Yes, Mr. Gonadakis.
Just generally speaking, maybe not specifically on the hiring freeze, but since we are non-GRF dollars, all of these orders still apply to us, even though we bring in our own revenue.
Yeah, so we don't know what next year's will look like, but as of right now, they do. What has happened historically in state budgeting when we have the deficit is, or when they're working to balance, OBM will author some sort of legislation that allows movement between funds, and so they will take non-GRF funding and move allocations. I don't know what will happen next fiscal year with that. So we'll kind of wait to see. My guess is that if the deficit, or if we need to balance, that could possibly happen. I know that happened in what was it, 2008, 2009 timeframe. And
Thank you.
I think.
Appreciate it. Thank you.
Sure. And I'll save the full financial update for you, Dr. Schottenstein, to go through. I think from our end, I guess the good news is that we were able to meet the 20% reduction for this fiscal year through absorbing those costs. Operationally, I want to point out the investigators have done a really nice job of filling their time with, there's some of their downtime with getting caught up, but also really seeking out some training opportunities. One of the trainings that we've held back on sending folks to is the Case Western prescribing training, because it's really expensive. It's typically, I think, about $1,600 per attendee. James was able to work out a deal with them where we're doing this again, web training, and they offered to allow us to pay what we thought was fair at the time, given our budget scenario. So we're going to be able to send an entire group of people through that prescribing training, which I think will be very valuable for both our enforcement attorneys and our investigators. With respect to licensure, you at the top of page 5 have some lines missing from your table. They got lost along the way somehow. The lines that are missing actually mirror the lines that are in the table below it with respect to new licenses issued in those different categories. To me, the data from the licensure activity is that while not ideal scenarios to have all of our licensed staff working from home, we are keeping up with the work. We do not have significant backlogs in licensure. The numbers that we're seeing are sort of normal variances in licensure numbers, and staff has been working really hard to get things approved quickly. So I think we're doing pretty well on the licensure front. So I commend Joe and his staff for that. They've put in a lot of time to stay on track with that. And then
Stephanie, how do you explain?
I'm sorry.
How do you explain the average days being? Because I know we're we're moving to move more quickly, but our average time doesn't seem to be reflecting that.
And are you looking at the top table there, Betty?
Yeah, I'm trying to. I think it's page 5.
Page 5.
Well, never mind. Go ahead.
Yeah, so I think that, I think some of this is the delay in, we're having and I'll let Joe jump in here if you want to jump in, but I know we've had different delays with fingerprints, different places not being open. Testing is not quite what it was. Joe, do you want to speak to that at all?
Yes, there's definitely been delays due to folks being unable to obtain background checks. Also for this month, in terms of time, we also have had a huge influx of applications. This is the training certificate time, so we had probably 2,000 applications come in total for the month. So obviously, they're not all going to be processed as quickly as we would like. I mean, it's just a very, very busy time for us. So when we would be, obviously the training certificates have taken some time, meaning that other applications have sat a little longer than, typical. It's just, that's very normal for this time of year.
Thank you.
I think we also had a significant push on the training certificates from the schools themselves. When we were talking about surge preparation, the schools were really pushing the residents to get those training certificates in sooner rather than later. We sometimes see that, from what I understand from Joe, we sometimes see those applications stretch from spring through July 1st when those programs typically start, with the promise of being able to start early in their residencies. We had, I think there was one week, Joe, we had maybe 700.
It was almost 800 applications in 1 week.
Yeah, so an inordinate amount quicker, probably about the same amount of training certificates. They just came really fast this year.
Yeah.
Any other licensure questions?
I'm curious with the orders that we have adopted, maybe orders isn't the right word, but whatever the right word is, that we've adopted since middle of March, have we seen anything positive or negative or different in the field for which we regulate? It's a pretty broad question. I know nothing specific there, but just generally speaking, have we seen any hiccups or positives or negatives in the activities we've taken under the current situation we're in? Just more informational.
Yeah, no, good question. So I think, a couple of different buckets that we had there. We took some action on the telehealth. I think we had a lot of questions as we started. People getting going with telehealth. I don't think we've seen any, what should I say, any negative effects of that on our end anyway. That might be a delay too, that we would see that down the line. I think it will be an interesting discussion for us for the going forward as more patients got used to telehealth and really liked telehealth. So that will be something for us to, I think, consider as we go forward. With respect to licensure, I think that, there was the delay that the legislature put in until December 1st or 90 days after the pandemic, whichever is latter. And I'm not seeing that much of a delay in people applying. I think most people are still applying for their license on time. And we have systems set up to catch folks who don't, and that they then will have to by whatever that new deadline is. So I think from those two, and then I don't really know that we know yet on what the uptake is on people still complying with CMEs, even though we have suspended that requirement. I would have to imagine that some folks are getting caught up on online education opportunities because they had some downtime. So I don't know that we know that yet, but we probably will over the coming months as people renew. In your packet too, you have complaint information. We've included that for a few months now. Our next big lift with that is pulling together a good data story for you to tell you what our trending is looking like with complaints, how long they're staying open, and how long we can how many we're closing every month and how many we're actually seeing stay open. And then finally, I'll just speak quickly about our communication and our constituent work. Communications has been putting out a lot of great material. I know a lot of different agencies are looking at our website for modeling and for replication. So I'm really pleased with how much work the communications team has been doing to keep our licensees and frankly, I think just general and the consumers aware of what's going on in our different licensed fields. There have been a lot of email pushes, tweets, LinkedIn's, and we're getting good reception from that. People are hungry for information, so if we can provide that to them up front, it helps us answer a lot of questions on the back end. But speaking of questions on the back end, I'd like to give a special thanks to 3 people who have just been inundated with constituent inquiries. So Jill Reardon, Sierra Lynch, and Jerica Stewart have been fielding our constituent inquiries just since April, and this is actually out of date at this point because I know they got a couple hundred emails just in the last day. They fielded over 1,200 emails in the month of April, and you know, a couple hundred calls as well. So a lot of those emails end up in calls when they sort of get into a loop. And again, licensees, a lot of information coming at licensees right now, and we're trying to keep up with them in real time. And I think we're handling that really well as a board without those escalating to either their representatives or the governor's office. We've had some good feedback that we're doing a good job handling our own concerns and not letting those get escalated. So I'm really pleased with that. Maybe a good segue into the massage therapy. As you saw in the email last night, we did issue the release of the guidelines that are out there for massage therapists, acupuncturists, and cosmetic therapists. I think this hopefully answered a lot of questions for them and what practice looks like going forward as of Friday. We'll continue to educate our licensees as they have questions or as we need to go out into the field to address concerns from complaints. Our goal really is to educate and get folks in compliance and work with our local health departments and work with the Department of Health to make sure that our licensees are following those guidelines. I'm happy to answer any questions about that, about those massage therapy guidelines as well. Yes, Dr. Swain.
Hi, everyone. First of all, great job on the guidelines. I thought they were very comprehensive. I thought they did an excellent job of protecting the public. I know Dr. Schottenstein, Dr. Feibel also helped out with those, and I thought they were excellent. There's a lot of content in there, and it's sort of split between mandatory and recommendations. And as far as that sheet goes, did you guys discuss the possible confusion that may occur between having them side by side? And secondly, did you ever think of maybe putting some things in bold that you might want to highlight just because there's just so much content in there? But otherwise, I love the content. Just some questions.
Great, thank you for that. I mean, thank you for your email too. That helped us answer some of our questions as well. I know you gave me some feedback via email. So the layout of the document is the layout that is used by all of the different sectors that have been opened as part of Responsible Restart Ohio. I think we very much recognize that it's very content heavy for our licensees. So what we are working on, and we started this immediately when those guidelines went out, we're working on an FAQ document that we will be, we're going to work on that with the Massage Therapy Association. We're going to create some questions and then hopefully flesh out some of those bullet points in an FAQ. And I think on our website, we can render that information a little clearer to them and break of that standard format document that's on the ODH website. So great point. We need to visually make it a little easier to understand. Great. That's all I have. If anybody has any other questions.
Thank you so much, Stephanie. So can you all hear me, by the way? Okay. This month we are incorporating committee work into the full board meeting. So next on the agenda, we will be going through each committee and addressing any business that needs to be conducted for May. So I'll go through Finance Committee business for a moment, please. So looking at our fiscal update for March 2020, revenue was $1,325,847. Months of revenue greater than $1 million are very good months for us. And typically it is the month of March in an even fiscal year that is our biggest month of our 2-year cycle. It's just a function of renewal dates and that there are a greater number of licensees that are due based on the first letter of their last names. We had a net fiscal revenue of $455,387, and our cash balance increased to $5,780,690. That cash balance is a record high for us. We had been anticipating additional high revenue months for the rest of the fiscal year, April, May, and June, especially for June, when respiratory therapists and dietitians are supposed to renew. But with the passage of House Bill 197, the deadline for license renewals has been pushed back to as late as December. And so it's likely that many licensees will wait until the deadline to renew their licenses. That means we could experience a decrease in revenue for several months, followed by an upsurge in revenue toward the end of the calendar year. Our expenditures are down 2.9% year to date as compared to 1 year ago. Revenue is up and expenditures are down. So right now we are in a financially healthy place. As noted last month, we have been asked to make a budget reduction of $259,209 for fiscal year 2020 by the Ohio Office of Budget and Management. And as noted earlier, we have done that. You may have noticed on the fiscal summary page that there has been an uptick in the amount of money spent on historical case review. So we are 50% of the way now through our historical case review with regard to the sexual misconduct cases, and we've spent about $82,580 on that. So we are continuing to make progress. And FYI, we're about 76% of the way through our working group tasks as a whole. With regard to the fines summary report for March 2020, we received fines from 3 sources: disciplinary fines, CME non-disciplinary fines, and money received from collections. That totals about $30,000. We have received $168,109 in total fines year to date out of total fines assessed of $252,000. Going forward, we will start to see a decrease in CME fines related to the board's motion to suspend enforcement of the CME requirements in light of COVID-19. So there's no new business, and that concludes my report. So next, Dr. Bechtel will be presenting an update from the Medical Marijuana Committee, please.
As previously reported, the board voted to move forward with an expert review of the petition to add cachexia to the list of qualifying conditions for the treatment of medical marijuana. And the board has contracted with an expert to review the petition. We expect the report to be available by the end of this month so that the committee members may review it and discuss it at our June 10th committee meeting. At the June 10th meeting, the committee expects to vote on petitions regarding cachexia, anxiety, and autism, and the full board will take action on the committee's recommendations at the July board meeting. Official adjustments and statutory timeliness will be made at the June board meeting. And this concludes the report from the Medical Marijuana Expert Review Committee.
Thank you, Dr. Bechtel. So I'll provide an update on the Sexual Misconduct Committee from this morning. So we had 3 main items on our agenda. We talked about the FSMB consultation review, which is essentially their auditing of our processes. So they have a great team with members from the FSMB itself and from around the country as well. You know, we've provided them, you know, a lot of documentation regarding, you know, our organization and our workflow and such. And so they're going to be interviewing staff, secretary and supervising member, and myself as well, and you know, and other board staff as well, of course. And they're going to compile a report. They expect to wrap that up by the end of the fiscal year. One good piece of news is that the original cost that was going to be roughly $30,000 is down to $15,000 now because they're not going to be traveling. And so they saved that expense and we're getting a discount from them. So we're encouraged with this process so far. When the FSMB audit is concluded,
we're going to circle back at that point with the Office of Budget and Management because they're going to do an internal audit as well. We're not sure what the cost of that will be, though, if any. Our second item on the agenda had to do with victim advocate training. James Roach has been working with the Ohio Victim Witness Association, providing trainings for investigators. They're doing a half-day webinar training, and it's a good use of our time, and it's tailored to the board needs. And so we also talked about how where we originally had envisioned using victim advocates as contract workers that were regionally based around the state, what we've sort of learned is that our staff is more comfortable using internal resources because it's a more dedicated kind of a resource. Contractors have not been ideal because we just don't have the continuity or the availability that we want in real time. So we do have a budget concern to work through, but I think that's how we are hoping to proceed. And then our third item of business at the Sexual Misconduct Committee had to do with the historical case review. We feel like that is progressing well. We're thankful that the Assistant Attorneys General have been kind enough to donate their time to us. We have about 10 of them who are working through cases, and that's at no expense to us. And then we have another 10 contractors who are continuing to pursue this as well. As time has gone by, the average length of time that it takes to do a review has gone down substantially because we started with the most complex cases first. And I'll also say that we started with the active licensees first, and we're almost done going through all of the active licensees, which I feel good about. The staff has spent about 3,000 hours total on the work group action plan. 2,000 of those hours are on the historical case review, and that does not include contractor review time. But we're trending down so that lately it's maybe 1 or 1.5 hours per review time. So we're hoping to, accelerate this and get this done in a timely manner. So I think that concludes my report. And so next, Dr. Sohn will present the policy committee, please.
Yes, thank you, everyone. Hi. Sorry, just making sure I was off mute. Thank you, everyone. Due to COVID-19, the policy committee meeting and the agenda was wrapped into the main medical board meeting that we have done here today. So I have nothing else to report. Thank you, Dr. Schottenstein.
Thank you so much. And so next is licensure committee presented by Dr. Safran.
Thank you, Dr. Schottenstein. The first item is a minutes review for the April 8th, 2020 meeting. I would entertain a voice vote to approve the minutes.
Motion, Dr. Edgen.
Dr. Edgen.
I'm sorry, Dr. Safran, those minutes were actually approved at the May meeting. In May, we approved the April committee minutes, so we don't need to do it this month.
Perfect. The next item, and I apologize in advance for names. Erin Ruskowitz has applied to restore her massage therapy license in Ohio. She has not practiced within the last 5 years and has never taken the MBLEX. The motion before you is to move to approve her application for restoration of her Ohio license contingent on passing of the MBLEX within 12 months from the date of mailing of the notice of opportunity for a hearing. Please note that we increased the time from 6 months to a year because of the pandemic and the ability to get into testing centers.
Thank you. Is there a motion?
So moved.
Dr. Bechtel and
Second.
Dr. Rothermel, thank you. Any further discussion on the motion? So roll call vote, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes?
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgen,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella, Dr. Cacarella? Yes, Thank you. Mr. Ganadakis,
Yes.
Ms. Montgomery.
Yes.
Thank you. Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes.
Next item is Dr. Chuktagi has applied for a medical license, and he has requested that his experience and training in the United Kingdom and the United States be deemed equivalent to 24 months of graduate medical education through the second year level of graduate medical education. The motion is moved to grant the graduate medical education equivalence as outlined in 4731.09A4B to be granted a license.
So moved.
Motion. Dr. Rothermel and
Second.
Dr. Bechtel, thank you. Any further discussion? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes?
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgin,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes.
Next is Dr. Hussein has applied for a medical license and has requested a waiver of the USMLE 10-year rule. And he has requested that his experience and training in the United Kingdom and the United States be deemed equivalent to 24 months of graduate medical education through the second year level of medical education. The motion is moved to approve the good cause exception of the, I'm sorry, I think this is for exception of the 10-year rule as outlined in 4731-6-05C2 and accept the examination sequence and grant the medical education equivalence as outlined in 4731.09A4B to be granted a license. So there's two issues.
So move.
Second.
Dr. Cacarella, Dr. Rothermel, thank you. Is there discussion? Okay. Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes?
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgin,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes.
Last one is Dr. Zubari has applied for a medical license and has requested a waiver of the USMLE 10-year rule. Move to approve the good cause exemption to the 10-year rule as outlined in OAC 4731-6-05C2 and accept the examination sequence to be granted a license.
Motion?
So moved.
Dr. Rothermel and Dr. Edgin, thank you. Is there discussion? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes?
Mr. Giacalone,
Yes.
Dr. Sohn, Dr. Edgin,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes.
This ends the licensure report. Thank you, Dr. Schottenstein.
Thank you so much, Dr. Safran. That was great. Next on the agenda, please turn to the compliance section. Do I hear a motion to approve the compliance staff's reports of conferences for April 7th, 9th, 10th, and 13th, 2020? Motion? Dr. Cacarella and
Second.
Dr. Johnson, thank you. Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Sloan,
Yeah.
Dr. Edgin,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes. First with you.
Mr. Papadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Fiber,
Yes.
Dr. Bechtel,
Abstain.
and myself, Michael Schottenstein, yes. Thank you. At this time, we will consider the probationary requests in today's agenda that have been prepared by the review and compliance staff. And
Dr.
Sorry.
Schattenstein, could we mark Dr. Rothermel's vote as abstain?
Yeah, abstain. Yeah.
yeah, so I wondered about, okay, sure, of course. Thank you so much. At this time, we will consider the probationary requests in today's agenda that have been prepared by the Standards Review and Compliance staff and distributed to board members. Before asking for a motion, does any board member wish to consider a probationary request separately? Okay. Do I hear a motion to approve the secretary and supervising members' recommendations for the probationary requests? Motion?
So moved.
So, second.
Mr. Gandadakis, Dr. Cacarella, thank you. Roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Soen,
Yeah.
Dr. Edgin,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Gandadakis,
Yep. Yes.
Ms. Montgomery?
Yes.
Okay. Dr. Feibel,
Yes.
Dr. Bechtel,
Abstain.
and myself, Michael Schottenstein, yes. That concludes the May 13th, 2020 meeting of the State Medical Board of Ohio. Do I hear a motion to adjourn?
So moved.
Dr. Edgin and
So
sorry,
moved.
Dr. Bechtel. Thank you. Voice vote, all in favor? Aye.
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 All opposed?
Aye.
Okay, the time is 12:29 p.m. and the meeting is adjourned. Thank you, everybody. It was great to see you.
Stay well, everyone.
Thank you.
Well.
Stephanie.
Take care. Take care.
Everybody be well. Nice to see you.
Dr. Ed.
Take care.
Dr. Edge.